Good morning. I'm Gayla Austin. I'm a lawyer, and I'm the founder of Austin on Law and Ethics. I'm looking at my notes, and we're going to talk today about when you have had a hearing or some other kind of legal proceeding, and the prosecutor has deleted your defense, destructed it, thrown it out. Anyway, it's gone missing, and no more defense be had. So, in my case, I'm talking about this because it doesn't reveal any confidential information. And because, first of all, what is your defense? So say you get pulled over in your car, and what is your defense to that? I wasn't speeding, officer. I wasn't drinking, officer. And the officer thinks that you are, and say, for example, and says, no, we're going to have a hearing anyway. Or in my case, there was a video and there was a transcript in a hearing. And the state bar prosecutor deleted it. Let's see the clip. So here I want to go over this a little closely because it's important in these to see what the documents say. So here we have a lawyer, my lawyer, asking for a video and transcript recording because it's important. It was on Zoom and they were handwritten notes. There was a judge there. Donnell is the judge, and the state bar prosecutor, MM, that stands for Melinda McCorkle, and that my motion that I filed is the same as all the ones the judge has seen on the bench for 20 years, and that is the recollection. And that's what we are looking for, is that hearing that went missing. So here it is. Nobody has it. And I say, gee, I'm not surprised, because this is what you're talking about. A prosecutor that isn't doing what they should be doing. All right. And so we say from the staff, I'm concerned this hasn't been preserved. How can we recover this? See this here? Do you have thoughts of how we can recover this? It actually can be recovered by the state prosecutor, of course. And they choose not to do that. And so now the prosecutor's office says, oh, well, the person that was in charge of this left, and we hired someone else that doesn't start for the end of the year, and I'm unable to recover it. So we just had this hearing and in April, and it was deleted. Here's some more on the email. No transcript. It was reported. No, where is it? And then importantly, down here at the bottom, it says, I don't have the completed record. This is from the state prosecutor's office. I don't have the record. And we're asking again, do you have it in paper format? No, we don't. So then it comes out further. Has it been filed? No. And it is just gone. So this is a distinction when your defense is in a hearing. And I want to suss this out a little more, meaning this is that, it's one thing you have evidence, let's say in that car stop, were you speeding? Were you drinking? Were there bottles in the car? Were your lights on? Those are all kinds of evidence. But when you have a defense, an actual defense that negates what you're getting charged for, so maybe in the pullover example it is, well, there was a body cam and it shows that in a 40-mile-an-hour zone, I was going 35. That's huge. It throws it out, does it not? And in this case, here's a video and a transcript and the judge. And what is being said is that this motion is the motion that is required here, a motion to resign. It looks like all the ones I've seen for 20 years. Let's go back to the beginning of that, because that is what is important about this. I'm back on page 1. Do you have the handwritten notes? What Donnell, that's the judge, said about your motions being the same as all other motions he saw when he sat on the bench for 20 years. That would negate the charge, and it's been deleted. And so let's talk about, well, what happens right here. And there are rules, and that is what, of course, we are talking about, because I've been noticing in the general discourse, as I've been saying, we talk about cases that come down, and we need to be talking about that. We talk about rules in those cases, and we need to be talking about that. There are rules that govern the ethics part of this too, and they are meant to dovetail each other and work together with each other. But let's look at this one. This Rule 37 is a federal rule of civil procedure. It says failure to make disclosures or to cooperate. So when you have a prosecutor that is failing to cooperate, and what I mean by that, and it says specifically right here in E, failure to preserve electronically stored information. And I'm just going to read this. These rules are available to you if you want them, and I hope there's some discussion down in the comments. But it says, if electronically stored information, that would be the video and the transcript, because it is someone reporting that should have been preserved in anticipation or conduct of litigation is lost because a party failed to take reasonable steps to preserve it, and it cannot be restored or replaced through additional discovery. One of the things is, cure the prejudice, which means do something about it. I mean, we need to call the judge back in, perhaps, or we need to call me back in, perhaps, or you, to say, here, officer, I was going 35. Or in my instance, here, officer, here's my motion. It is what is directed by the courts here. Or presume that it was unfavorable to the person that deleted it, basically. Well, yeah, they didn't want the judge saying that. Or dismiss it and enter a default. And so this is really important. I think I'm talking about this today because I think it gets glossed over right at the beginning. Because maybe you're upset from getting stopped, or it's an employment situation, or it's some other situation right at the beginning. And the defense part of it gets mashed together with all the rest of the evidence. And we don't want to do that. This defense is just so important. And we'll talk about the rest of the evidence in the upcoming videos. But I want you to be aware so that you can preserve your defense and so that you can assert it. And so it says right here, this is the part of it that deals specifically with electronic evidence, but you can see that there are other rules that deal with, you can have be compelled to produce it. Where is this, in other words, rather than just skimming over that very first step. Very important, I think. And what happens with somebody that tampers with evidence, so that body cam went missing, or you can't see it, or your breathalyzer isn't accurate, or never was filed, or some email from work doesn't show up. I mean, what is tampering with evidence? And what it says is when someone knowingly alters it, conceals it, falsifies it, destroys it. We're talking about a federal rule here, and it is highlighted right here, 18 United States Code, section 1519. It's a crime to tamper with evidence in official proceedings. And this is really important for you of something that's missing. I think we tend to think, well, if everything isn't there, that's okay. We're missing one thing. No, especially not here when it is your defense. It is what is defending you from the crime, the charge in the first place. Really, really important to not have that go missing. And what needs to happen is the proceedings just need to stop. Just stop, and let's figure out where this is, because otherwise you just go on to be charged and perhaps convicted on whatever evidence is there, and that's just not accurate. And in this code that we're talking about, I want to say the full text says, whoever knowingly alters this, mutilates it, conceals it, falsifies it, makes a false entry, obstructs it, influences it, she'll be fined and imprisoned not more than 20 years or both. And I think there's also a misconception that because it's a government actor, say, maybe it doesn't apply to the person. But that's just simply not true either. And we'll talk about that. Yes, government actors have immunity, but they don't have absolute immunity. They do not. And so be aware of, on your defense and on your evidence, this must be disclosed. And if something has happened to it, then the proceedings need to stop and go in a different direction, which means we can't go forward until we have this. Something has to happen right here. And I want to talk a little bit about my case so you have some context for this. And so I was representing an estate. And hopefully, probably many of you are familiar with that. I mean, you've had an estate in your family. Most people have at some point. And the estate had to do with real property, and that's a really common thing too. And the estate had a personal representative. And that personal representative was court ordered to sell the property at a sheriff's sale. And she said, I'm not going to do that. She didn't tell me that, but she called up a realtor and said, I'm going to sell it. Just sell it by realtor. That's a crime. Why? Because you have a court order telling you what to do. And we'll take this up in next video. I don't want to make this into a law school class, and I also don't want to make it such that there's too much in here, because what we're talking about today in this video is your defense, that very piece of evidence that negates the whole charge against you. And in my instance, my rules say that if someone is doing that, I'm required to resign. And we will take that up in next video about the crime fraud exception and how it is and why it is I would be required to resign if someone were committing a crime. I mean, that makes sense, doesn't it? I can't continue to represent you if you're doing something illegally. That makes me complicit with it. And we'll cover that too. I mean, just be aware of your own, or for your client, if you're a lawyer watching this, what is your defense? And this is called exculpatory evidence. And we'll cover this a little bit more. But be aware and look at your documents. Take care and see you on next video.